Hello, members of the Hague Conference. I'm Edwin Smith from the United States. I'm a practicing lawyer who deals in commercial and insolvency laws, and I'm pleased to be here with my friend and colleague, Professor Neil Cohen. Neil?
Yes, hello everybody. I'm Neil Cohen, and I'm on the research faculty of Brooklyn Law School in the United States. For many years, I've taught both secured transactions law and conflict of laws. And since the project we're talking about now is at the intersection of those, it's a project that I'm particularly looking forward to. Along with Ed, I've been involved in the development of many international instruments in the area of secured transactions law, including parts of those instruments that deal with choice of law rules. And again, that's really our topic here today. So what I'd like to do is we can just turn to the next slide, Ed. I think you're controlling those, right? There we go.
Yeah.
Let's talk a little bit about what we'll be talking about, and then get into the to the meat of the topic. Security interests are really important to a modern credit economy. They work very well to increase the availability of credit at lower cost by increasing the set of assets that can be made available to satisfy obligations. And by doing that, they lower the risk of a transaction for a creditor. Secured transactions law typically contains both substantive rules and choice of law rules dealing with cross-border transactions. But most existing rules that are out there weren't drafted with central bank digital currencies in mind. This is such a new development. We're really just on the cusp of it, that we don't have rules yet, for the most part, that are tailored to CBDCs. And as a result, as substantive law develops in this area, it's likely that it'll be a while before there is anything like harmonization from state to state, from country to country. The result of that, the result of the fact that there's likely to be different law in some countries than in others, is that we will need very good choice of law rules in order to determine which sovereign's law governs the various issues that can arise in the context of a secured transaction, a transaction in which a central bank digital currency is collateral. The bullet points that you see on the screen are our attempt to identify some of the important choice of law issues that will arise. The middle four points there are the four that we'll be addressing in this talk. What are the rules related to CBDCs as original collateral, as proceeds of other collateral? What happens when the CBDC is not the original collateral, but the right to receive payments in that form is collateral? And finally, how does this change depending on the method in which the economic owner of the CBDC holds those currencies? And we're going to go through the choice of law issues that arise in the context of each of them. So Ed, why don't you turn to the first one, choice of law rules for the CBDCs as original collateral?
I'm happy to, Neil. Once again, just to emphasize to everyone, we're talking about choice of law rules relating to central bank digital currencies and only security interests in CBDCs. So we start off with the question, if there is a dispute that arises in a particular state, will that state characterize the CBDC as such for purposes of determining its own choice of law rules? So we have a characterization issue right at the start when we're dealing with the forum in which the dispute arises. That forum will then point for characterization to the law of either that jurisdiction or another jurisdiction, which will have its own substantive characterization rules. But here we're just talking about characterization for purposes of choice of law. Then there is the question, okay, we have a collateral that is characterized under the choice of law rules of the forum as a CBDC, which law determines whether that security interest is effective between the parties, between the secured party and the grantor. It could be the law of the security agreement. It could be some sort of lex recite analysis, but there has to be some sort of determination as to what law governs the actual creation of the security interest. And then we get to the question of the effectiveness of the security interest in the CBDC against third parties. Which law determines whether the security interest does more than just being effective between the parties, but also binds third parties? And who might those third parties be? They might be a competing secured party. They might be an insolvency administrator. There might be a creditor who has obtained some sort of a lien or attachment on the CBDC. It may be a buyer or other transferee of the CBDC. Those are all people who could be affected by this. But then there's the choice of law question on top of that. Even if the security interest is created and effective against third parties, how does that security interest rank with respect to competing secured parties? We'll need a choice of law rule for that as well. And then finally, enforcement of the security interest. Usually a secured party has certain rights, either established by statute or by contract. And what law determines what those rights are? So that's the menu when we're dealing with the CBDCs as original collateral and the choice of law issues. Neil, tell us a little bit about what happens if the CBDCs are proceeds of other collateral.
Certainly, Ed. And let's turn to, thank you for moving the slide. In very many credit transactions, the primary collateral is not cash or its equivalent for many reasons. The amount of money, the amount of cash that a company has on hand at any one time can fluctuate greatly. And the more money, of course, the debtor has, the less need it has for credit. Rather, very often the primary credit, and certainly the primary the primary collateral, or the primary collateral relied on by a creditor, is not so much money, whether it's in the form of cash, bank accounts, or digital currency, but rather it's other assets. Assets like inventory and receivables, for example. But inventory and receivables exist primarily in order to be turned into money. Companies have inventory in order to sell it and generate funds. Companies' receivables exist so they will be received, so that the company will receive something for them, will receive payment. And as a result, if you're a creditor and of extended credit, relying on the company's inventory and receivables or similar assets as collateral, you have to foresee the fact that those items of inventory or those receivables will not stay fixed forever. Rather, over time, many of them will be converted into proceeds. Something will be received for those assets. And very often in the economy that we're moving towards, what is received may be something that's in the form of a central bank digital currency. And so we need rules not only to address the issues that Ed just described in the context of transactions where the CBDC is original collateral, but also rules that deal with situations where the CBDC is what most secured transaction systems call proceeds of the original collateral. Those rules in domestic legal systems are often rather complicated, and one of the things we've learned is that they differ somewhat and sometimes significantly from state to state. The result is that we need choice of law rules to determine which state's law governs major issues that will arise when a secured creditor would like to assert its security interest in some other property against a central bank digital currency that is proceeds of that other property. And you can see on the slide there's at least 4 major issues for which a state will need to have a substantive rule answer. And since those substantive rule answers will likely differ from one another until domestic secured transactions law harmonizes, we'll need choice of law rules for each of them. The first is whether a secured party even has a security interest in a CBDC that would be proceeds of other collateral. Some states have very inclusive proceeds rules. Others have rather restrictive proceeds rules in terms of what comes along automatically from having a security interest in other collateral. The second, as Ed was discussing when CBDCs are original collateral, is what does it take to make the security interest effective against third parties? This becomes important because in many states, different types of collateral have different methods of third-party effectiveness. What happens when the collateral moves from one type, such as inventory, to another type, such as a CBDC? Does the original method of third-party effectiveness still continue to be effective, or must a change be made? We'll need choice of law rules to identify that question. And of course, whenever parties are interested in enforcing their security interests in any collateral, they're often in a situation where they're competing claimants for that collateral, other secured creditors, lien creditors, and the like. And so one has to know not only whether one's security interest is enforceable and effective as a general matter against third parties, but its rank order as opposed to other claimants. And again, priority rules tend to differ from state to state. And so a choice of law rule will be needed there. Finally, in one of the more complicated areas, when the proceeds are cash or cash equivalents, has to do with the fact that in very many cases, a debtor will mingle proceeds of inventory or receivables with other cash that it has. They'll all go in the same account, or they'll all go, in the case of cash, perhaps all go in the same cash drawer in a store. What does one do when a particular pot of value, whether it's an account with CBDC or a cash drawer, what does one do when some of what's in there represents proceeds of original collateral in which the party has a security interest in, and other parts of it do not, and you can't tell them apart? They all look alike. How does the law deal with this problem of commingling? And again, this is something that states don't always agree on, and as a result, a choice of law rule is necessary. So we have several rules that are necessary for this narrow but difficult area of proceeds. We have a few other areas that we'd like to talk about, and Ed, the next few are yours, and starting with the right to receive payments in the future as collateral.
Well, yes, Neil. Of course, you can have goods sold or services rendered and payments then being made to the supplier or provider. And what if payments are going to be made in central bank digital currencies? There are characterization issues here as well, because often the references in the transaction are to payments. In the statutes dealing with the sale or lease of goods, provision of services, there may be references to payments. How confident are we that CBDCs will be viewed under the choice of law rules of the forum as constituting payments for purposes of applying those choice of law rules? Typically, also, you'll see references to payment-like words like monetary sum or account. And so we have those issues as well. And then there is the fairly typical issue about whether a debtor can grant today a security right and an asset that it won't acquire until tomorrow. And to the extent that the forum has a choice of law rule for determining whether to look, whose law to look to determine whether the debtor can encumber future assets, we need to think of the CBDC as one of those future assets, and to what extent would the CBDC fall within whatever choice of law rule the forum has. Complicating all of these matters, when we deal going beyond just the original characterization and the proceeds of the collateral and the right to receive future collateral, we need to bear in mind that the resolution of these issues could depend on the method in which the CBDC is held. The CBDC could be arguably held directly by the grantor with whatever the issuing authority is. But we've also seen that a lot of thinking goes into whether the CBDC should be held directly through a bank account or indirectly through a bank account or with a financial intermediary. And would the choice of law rules change depending on the method by which the CBDC is held? It's conceivable that if the CBDC is held through a bank account or through a securities intermediary, the applicable choice of law rules will be those that deal with bank accounts or securities accounts and not necessarily CBDCs as such. So those issues need to arise as well. So I hope we've given everyone a little tour here. Neil, anything that you want to raise that we haven't already covered?
Well, yes, one thing, which is we've given a rather extensive menu of situations for which choice of law rules are needed, but we haven't really talked about how one would develop those choice of law rules. And if you can move to the next slide, let's talk. Yeah, let's talk a little bit about that. It's important to remember that we're not starting with a blank slate. Every state, or just about every state that has law governing security interests, also has rules that determine which state's law governs in the event that a transaction touches more than one state. But as we've talked about with respect to the issues that we have here, typically those rules have not been designed with the somewhat unique nature of central bank digital currencies in mind. And so part of the task is to assess what is there already, how much of that works, how much of this subject needs especially tailored rules. And again, not only are we not starting on a blank slate in terms of the existence of private international law rules or choice of law rules at all, there's also some international work in this area that's at least something to look at as a starting point. There's a variety of instruments, we might look at. The Hague Securities Convention, for example, relates to the last point about which Ed spoke, about what happens if the CBDC is held in a securities account. Also, there are several UNCITRAL instruments, particularly the UNCITRAL Model Law and Secured Transactions, which has an entire chapter about choice of law issues. Cape Town Convention as well needs to be consulted in this area. But again, none of them were developed particularly with digital currencies in mind. And so once we fortify ourselves with all this background knowledge, we still have to decide, or lawmakers have to decide, how to develop rules that are particular to or tailored to security interests in central bank digital currencies. And in some ways, there's a tension when people are developing, when states are developing private international law rules, there's often a tension between what I sometimes call conceptual approaches and practical approaches. And the history of choice of law rules and their development has been about the tug of war in many ways between those two ways of approaching them. Certainly historically in the US and many other countries, the history of choice of law rules was to identify connecting factors, either in a way that is somewhat mechanical and didn't vary, or in a sort of a soft type of analysis where the conclusion about what the most logical connecting factor was might differ from state to state, or excuse me, from transaction to transaction, depending on the nature of the transaction. The other end of the scale from this sort of conceptual approach is an approach that emphasizes certainty and predictability. Those two aren't quite the same. For certainty, we're talking about having rules that ultimately generate one answer and that we know what the answer is. So in addition to having whatever substantive dispute there may be between parties, there is no doubt about which state's law governs it. But in the area of secure transactions, it's important not only to have certainty of result in terms of what state's law governs, it's also important to have predictability of that result. Parties should be able to know on the way into a transaction which state's law will govern any issues that arise, whether it's issues unique to their transaction, such as enforceability of the security interest, or issues relating to conflicts with others, such as priority determinations and the like. And in many ways, certainty and predictability rules are often constructed somewhat differently and perhaps even arbitrarily than rules that are based on logical connecting factors. And so as the HCCH or any organization or any state seeks to develop choice of law rules in this area, that's one of the things it will have to take into account, which is how does it develop those rules. And in fact, as we go forward, we may see, as many people assemble to talk about these rules, other factors to take into account as well. And so we need to identify the issues for which choice of law rules are needed. And then we need to think about how we will satisfy that need, how we will go about developing those rules in a way that is not only logically sound, but also practically effective. And that's probably the hardest part of the task here going forward.
And of course, we're not writing on a clean slate, as Neil mentioned. We have the work from Trial and UNIDROIT and HCCH itself to fall back on in so many different ways here. Neil, thank you very much for joining me on this presentation, and good luck to the members of the Hague Conference for a successful meeting in October. Thank you all.
Thank you.